Made please, Lord.
Yes.
My Lord, I crave your lordship indulgence to mention item number 12. I have taken the consent of other side. Lord, can it be fixed sometimes in the month of May, my Lord? If it is possible on 14/5.
May we cannot give dates. We can fix without dates.
Then, my Lord,
Heard Mr. S. Datta, learned senior counsel appearing for respondent number 1, 2, and 3, who prays for an adjournment on the ground of personal difficulty. He submits that he has informed learned counsel for the other side regarding his prayer for adjournment, who does not have any objection to this. Hence, the prayer is allowed. This matter will be listed in the third week of May on a date to be fixed by registry.
much obliged.
Please, your lordship. I beg to mention item number 9 may be possible for the day.
Have you informed the other side?
Yes.
For the appellant.
Heard, Mr. What is your name?
A Patter. A Patter.
A.
On behalf
Patter.
of Jay Sharma.
Appearing on behalf of Ms. J. Sharma, learned counsel for the appellant, who prays for an adjournment.
Appellant respondent.
For the appellant. They are for the respondent.
Learned counsel for the respondent, who prays for an adjournment. Ms. J. Sharma, learned counsel for the appellant, does not oppose the prayer. Hence, the prayer is allowed.
Lordship may kindly fix a date.
Let this matter be listed on 21st of July.
June.
Maybe too long, maybe kindly sort.
Then we cannot fix.
Okay, your lordship.
Okay.
Without date, registry will fix.
Yes,
lordship.
lordship. Obliged, lordship.
Lordship.
May it please your lordship. Lordship, with your consent of the other side, I beg to mention item number 11, lordship. Mr. P. Bodolo is annual, lordship. Kindly pass over for the date.
Heard, Miss, what is your name?
B.S. Ojha.
B.S. Ojha, learned counsel for the respondent, who submits that the learned counsel for the conducting counsel for the respondent is unwell, and on that ground she prays for an adjournment. She has submitted that she has informed learned counsel for the appellant regarding her prayer for adjournment, who does not have any objection to the same. Hence, the prayer is allowed. Let this matter be listed after 2 weeks, after 3 weeks on a date to be fixed by registry.
May please, your lordship. I wish to mention item number 5, my lord. 5 and 6. Another person. In this case, the youngest counsel, my lord, for the appellant, yes, who said he informed that he has personal difficulties today. And
What happened?
he has personal difficulties today.
You have informed the other side.
No, my lord.
Then wait for your turn.
Lordship.
It is 4 and 5 only. It will come soon.
Lordship.
Yes.
May I please, your lordship? Your lordship, listing of 2 MSc appeal in the order column, your lordship. Any date, your lordship, please.
Listing
In order column.
senior court is there.
No, that court is not available today.
Okay. When do you want?
Any two appeal, your lordship. One is of both of 2019.
6th of May.
Oblige, your lordship.
Item 3.
What is to be done?
Otherwise, lordship, this first time scan copy need to be called. It's a motion item also, lordship.
Yes.
May please, your lordship. Second application, lordship. Okay. Item 3. Item 2.
Second time.
Second time, lordship.
On what ground?
New ground, lordship. Actually, the conducting counsel is in another court, lordship.
20B to C.
20B2C. Translated, lordship.
Okay, we'll call for the scan copy. Heard, Mr. What is your name?
S. Hussain on behalf of D. Medina.
S. Hussain, appearing on behalf of Mr. D. Medhi, learned counsel for the petitioners. Also heard Mr. K. K. Das, learned additional public prosecutor. Call for the scanned copy of the trial court records as well as connected case diary. The appellant shall take steps for requisitioning the scanned copy. List this matter on 25th,
Lordship, can it be on 14 May, Lordship?
on 14th of May.
Published.
Item 4. May I please, Your Lordship. Second bill application, my lord. On
Where
last
is the first rejection order?
page number 13.
Page number?
30. During pendency of that case, my lord, charge sheet has been laid, my lord, therefore this honorable court directed to approach the learned trial court. The trial court has rejected the bail application.
What is your ground?
Well, in this case, my lord, on last occasion, my lord, ground, my lord, the arrest memo has not been served, issued to the petitioner.
Your Lordship, I have asked to the IO, he has stated that within 10:30 he will give the report or what is, whether he has submitted the arrest memo or not. But
Okay.
till now I have not received.
Then we'll take it up at 2.
Two, Lordship.
At 2 we'll take it up.
Lordship.
Okay, at 2.
Item 5 and 6. In 5, my lord, the conducting council, my lord, association, he has personal difficulties to do.
Conducting council has some difficulty. What is 5?
5 is the appeal by the claimant, Lordship. And
On
6 is appeal by, cross appeal by the owner of the vehicle.
Why it has come up for orders?
It was, last order was, my lord,
9
by
to
your lordship on 23/2/2026, to be listed on 24/2026. Maybe because of that it has.
Whether service is complete?
Everything is complete, my
Service
lord. It was
complete,
picked
my-
for hearing also.
as per
Why?
matter dated 9/2, my lord, the respondent number 1, 6 time for filing objection, that was not filed till
Objection against?
against the appeal, my lord.
No, in one.
In 5, item number 5. Respondent number 1.
Respondent number 1, I am the respondent, my lord.
9 to order, service.
I am respondent number 1.
Item number 6 is delayed filing.
Yes, my lord.
Who is the appellant?
Appellant is the.
You are the appellant or?
No, I am not. I am the
You are the
respondent in both
appellant.
the cases.
In item number 6, my lord, we are the respondent, my lord.
Who is appearing for petitioner in item number 6? Mr. M.
Not available.
We will delink both cases.
And my lord, what has happened, my lord, this matter was, item number 6 was once dismissed for default. They have filed a restoration petition with condonation, and my lord, we did not object, and that was restored back to 5. Again, in the main condonation, my lord, they are not appearing.
Then we will delink item number 6 with 5.
Lordship,
If 5 is ready for hearing,
as your lordship wishes.
heard Mr. H.R. H.A. Ahmed, learned counsel for the appellant. Also heard Mr. R.K. Patra, learned counsel for respondent number
1.
1.
Cross objection. Cross objection of finance.
It appears from record another MAC appeal, which is yet to be registered, has been tagged with this, which is yet to be registered, that is MAC appeal bearing filing number 2403/2023, along with interlocutory application 669/2023 has been tagged with this case. However, no one has appeared for the petitioner in the said interlocutory application today, whereas this MAC appeal within bracket MAC appeals 174/2023
Item number 6.
is ready for hearing. Accordingly, the registry is directed to detach the IA 669/2023 from this appeal, and the instant appeal shall proceed in its normal course. Let this MAC appeal be listed for hearing on 23rd July.
Obliged.
And ito ay IA 669. None has appeared for the applicant on call. Mr. H.A. Chaudhary is appearing for
Ahmed.
H.A. Ahmed appearing for.
In this case, my lord,
What is the name of your client? Mr. Bhatra, you are appearing for
1, 2,
which,
3, 4.
I'm for respondent insurance company, my lord.
1, 2, 3, 4.
which insurance company?
My lord, 5,
New India.
New India, my lord.
Who is Puturam Boro?
He's the owner of the vehicle, my lord.
Okay. Appearing, Mr. H.A. Chaudhary,
Ahmed.
H.A. Ahmed appearing for respondent number 1, 2, 3 has
1, 2, 3, 4.
1, 2, 3 and 4 as well
On
as
behalf of S. Hussain, maybe on behalf, I am appearing on behalf of S. Hussain. I have not filed.
H.A. Ahmed appears on behalf of Mr. S. Hussain, learned counsel for respondent number 1, 2, 3 and 4, as well as Mr. R.K. Bhatra appears for respondent number 5. Let this interlocutory application be listed again on 11th of May.
Item 7.
Obliged.
My lord, appeal was admitted earlier and we have taken steps, my lord. I think this is for my lord steps, my lord, service report.
When have you taken steps?
My lord, step 2.
3. Okay.
Huh?
Heard Mr. A.R. Sikdar, learned counsel for the appellant. On perusal of the office note dated 24/2026, it appears that the service report in respect of notices issued to respondent number 1 to 4 are still awaited. Stop. The registry is directed to place the postal track consignment report of notices sent to the respondent number 1 to 4 by speed post before this court on the next date fixed. Let this matter be listed on 6th of May.
Item 8.
May I please lordship? Lordship, my senior is in different court. Kindly pass over to letter for backup.
Yes.
I'm agree with you. My senior is also coming.
Lordship.
Pass over for the day or for the time being? Okay. We'll take it up after some time.
Yes, Lordship. God bless.
May it please your lordship. Here in this case, my lord, I am appearing on behalf of Mr. N.N. Upadhyay, my lord, for respondent number 1. He is indisposed, my lord. So matter may be fixed on 7, my lord. We have also taken consent from the petitioner's side, my lord.
I am for the appellant, my lord.
You have no objection.
No, he called me yesterday.
Heard Mr. S. Count, learned counsel for the appellant. Also heard Mr. What is your name?
S. Upadhyay,
S. Upadhyay appearing for
N.N. Upadhyay.
Mr. N. Upadhyay, learned counsel for respondent number 1, as well as Miss P. Devi. Miss N. Burman appearing for respondent number 2. Respondent number 2 on behalf of Mr. D. Nath, learned counsel for respondent number 2. Mr. Upadhyay, learned counsel for respondent number 1 submits that the conducting counsel for respondent number 1 is indisposed, and on that ground prays for an adjournment. The prayer is not opposed to by learned counsel for the appellant, hence same is allowed. Let this matter be listed when?
On 7th of May, my lord.
7th of May. Ityadi.
Or in the month of June, my lord.
It will go to July.
June, my lord. In between days, May.
कितने दिन में पड़े? 21 July.
Oblige your lordship.
Mr. Chetri, I'll come once other side comes.
Can it be taken some other day, lordship? I am not feeling today.
Okay. But you have to inform the other side.
I will inform. Short date may be given, lordship, as your lordship is convenient, my lord.
It is part-heard matter.
Yes.
Heard Mr. B. Chetri, learned counsel for the petitioner, who prays for an adjournment on the ground that he is not feeling well. Considering the submissions made by learned counsel for the petitioner, the prayer is allowed. Let this matter be listed. 11th of June.
No, all of short like otherwise whole matter will be in flux.
May last. May second half.
Second.
22nd May.
Evidence to solely as a other. No, that evidence solely as a two. Otherwise matter will be in flux.
Before 15th of, before 15th. 12th of May. You inform the council for the other side.
I'm sorry, man.
Anybody of first name? Item number 1.
For reasons mentioned in the judgment, this CRPIO is dismissed. You are for the petitioner. CRPIO is dismissed. However, it is hereby clarified that by the order dated 5/10/2023 or by the impugn order, the present petitioners have not been restrained in any manner from entering into or using the proceeds of or enjoying the produce of tea leaves of the suit land.
Item 2.
for reasons mentioned in this judgment, this court is of considered opinion that the impugn order and the reasoning given by the appellate court in the impugn order cannot be regarded as a perverse decision or a reason without any basis. Hence, this court is of opinion that this is not a fit case to interfere with the impugned order in this revision application. Accordingly, the revision petition is dismissed. However, this court deems it appropriate to mention that though the respondent number 1 and 2 are not injuncted from using the name of Purvottar Simant Railway Karmachari Sangha during the pendency of the title suit number 633. However, they shall specifically mention that it is affiliated to Bharatiya Railway Mazdoor Sangha, which is quite different from the claim of the petitioners. That is, their union is affiliated to Bharatiya Janata Mazdoor Sangha. With above observation, this CRPIO is dismissed.
Obliged.
Pending item number 4.
I'm able to get it.
Yes. Yes, what is your submission, Mr.?
In this one, Lanet print code is the, in that arrest memo, there is no signature of the petitioner, even IO, and no any prominent person of the locality, which violates 36 of BNS.
Which judgment you are relying?
Coordinate bench judgment is. There are several judgments.
I have received it through Lordship WhatsApp communication.
And it is not available in the report also. In my lot, Saibul Hussain Lashkar, BA number 25 of 26.
Yes, Mr. Das.
It is similar with other persons, Lordship, but I have seen Lordship. However, 47 is there. It is true, Lordship, that I have seen there is no signature is there. If still Lordship, if it is my opinion, Lordship, if still Lordship want to clarify this, Lordship may give personal appearance of this SI Lordship, Rajan Bora.
No,
Otherwise,
you
Lordship,
inform him that how to prepare arrest memo.
Lordship,
You can communicate to
Lordship,
him
I will.
instead of disturbing him from his duties.
Lordship, it's okay.
How arrest memo should be
I will, Lordship.
prepared.
Lordship, I will.
And for their lapses,
Okay.
the accused
Lordship,
get
the accused
benefit.
will, Lordship, get the benefit of doubt, Lordship.
Heard Mr. H.A. Ahmed, the learned counsel for the petitioner. Also heard Mr. K.K. Das, the learned additional public prosecutor. This application under section 483 of BNSS 2023 has been filed by the petitioner Sabor Ali, who has been detained behind the bars since 21/4/2025 in connection with special NDPS case number 18/2025 under section 22 within bracket C/29 of the NDPS Act 1985. The gist of acquisition in this case, no, before this, it is pertinent to mention herein that this is for the second time the petitioner has approached this court. Stop. On the earlier occasion, his prayer for bail was rejected by this court by order dated 23/7/2025, passed in bail application number 2000/2022.
No, my lord, this is for co-request and this present petitioner, my lord, page 30.
Okay.
Not rejected, it was remanded to the trial court.
Passed in bail application number order dated 4/9/2025, passed in bail application number 2475/2025. As by that time charge sheet was laid, hence the petitioner was directed to approach the trial court. Stop. The trial court has also rejected the prayer for bail filed by the petitioner. The gist of acquisition in this case is quote para 3 from page 25. Apart from 36, what is your submission? Is there any other submission or only 36?
No, my lord, only 36. Other,
Learned counsel for the petitioner has submitted that the petitioner has approached this court mainly on the ground of violation of his fundamental rights guaranteed to him under Article 21 of the Constitution of India, as well as statutory rights guaranteed to him under Section 36 as well as 62 of the BNSS. Learned counsel for the petitioner has submitted that at the time of arrest of the present petitioner, no arrest memo was prepared and no independent witness was present or any signature of independent witness has been obtained thereon. As required under section 36 within bracket small b within bracket small Roman 1 of BNSS. Learned counsel for the petitioner submits that the apex court has in the case of D.K. Basu versus State of West Bengal reported in 1990 AR 1997 SC 6110 has laid down that what has been stated. The requirement of section 36, the requirement of attestation of an independent witness in the arrest memo is a mandatory provision. He submits that same has been also mandated statutorily by section 36 of the BNSS. And any violation of the same would amount to curtailing the fundamental rights of the petitioner guaranteed under Article 21 and 22 of the Constitution of India. He submits that a coordinate bench of this court has granted bail to petitioners under similar conditions. In support of his submission, he has cited rulings of the coordinate bench of this court in the case of Wahidur Ali versus State of Assam within bracket bail application number 263/2026, as well as Anwar Hussain Chaudhry versus State of Assam within bracket bail application number 3775/2025. On the other hand, learned additional public prosecutor has submitted that he has been informed by the investigating officer of the present case, that arrest memo was prepared under section 36 of BNSS at the time of arrest of the present petitioner. And a copy of the arrest memo is also produced by the learned additional public prosecutor. Same has been forwarded to him by the investigating officer of this case. The said arrest memo is kept in the record after marking the same as X. Stop. However, learned additional public prosecutor has fairly submitted that even though the arrest memo was prepared and though it bears the signature of the accused, what is the
No,
name of,
No, Lordship, his signature.
Signature is
Sober.
not there.
It is named in,
who is Sobar Ali?
it is the
Sober is the
petitioner.
petitioner.
That is not there, Lordship.
He's not the petitioner.
He is
He
a petitioner.
Lordship.
Sobar Ali.
Signature in the inspection memo, not in the arrest memo.
Oh, signature in the inspection memo. However, in the arrest memo, no signatures of any independent witnesses are there.
Lordship, few more lines can I add, Lordship? In section 37 will attract because in his possession, in my submission, Lordship, in his possession, this contraband has been found, commercial quantity, Lordship.
He also submits that the embargo of section 37 of the NDPS Act would be applicable in this case, as total 1935 grams of Sampex plus tablet suspected to contain tramadol was recovered from the possession of the present petitioner. Hence, he opposes the grant of bail to the present petitioner. I have considered the submissions made by learned counsel for both sides and have gone through the materials available on record, including the scanned copy of the trial court records. Though this case involves offense under section 22C of the NDPS Act involving commercial quantity of contraband. Hence, apparently, section 37 is applicable to this case. However, it is also a settled law that where there is a violation of any fundamental rights of the petitioner, of an arrestee, due to any breach of mandatory procedural requirement by the arresting authority, these fundamental rights of the such an arrestee would override the embargo of section 37 of the NDPS Act. In the instant case, it is apparent that though section 36 36 within bracket B, within bracket small one, BNSS now. 36 1B or 36B only?
6B. B.
Only B.
He is Lordship,
That
contract
is-
and countersign, Lordship, it is.
36,
B is only Lordship, only B, 1 and 2, Roman 1 and 2,
36 small b
Lordship.
within bracket small Roman 2 requires, and within bracket small Roman 1 required that the memorandum of arrest prepared at the time of arrest shall have to be attested by at least one witness who may be the member of the family of the arrested person or a respectable member of the locality from where the arrest is made, has not been followed. This court is of considered opinion that the arrest of the petitioner made in contravention of the provisions of section 36, read with section 62 of the BNSS, violates the fundamental rights of the petitioner guaranteed to him under section 21 of the Constitution of India. Hence, the embargo of section 37 of the NDPS Act is not applicable in this case. And accordingly, the petitioner is entitled to get bail in this case. So in view of the discussions made in the foregoing paragraph, the above named petitioner is allowed to go on bail of ₹1 lakh with 2 sureties of like amount. NDPS condition below the above. This bail application is accordingly disposed of.